Association's Sports Shorts, brought to you by our sponsor, the American Arbitration Association. Today, for episode 48, I'm pleased to have as our guest Bill Gorin, lawyer, private practice. So welcome, Bill.
Thank you for having me.
And the way we like to start our program is usually just to ask our guest to take a little time to first talk about what their practice is, the nature of their practice, and the path that they took to get there. So the floor is yours.
Thank you. I'm Bill Gorin. I am an attorney and consultant in Decatur, Georgia. My law and consulting practice focuses on understanding the Americans with Disabilities Act so that the client understands how to comply with that law and related laws. I have been involved with the Americans with Disabilities Act as an attorney since 1990. And so my representation side of the practice is quite small. That involves co-counseling with others, giving out legal advice, sometimes taking people through administrative processes. The much larger part of my practice is consulting. I have my blog, Understanding the ADA. I do a tremendous amount of training and presentation. I spent 12 years teaching people how to be paralegals, so I love that teaching aspect of it. And then I also work with attorneys around the country on their ADA and ADA-related cases, helping the attorneys, judges, and juries just figure out this incredibly complex law that is the Americans with Disabilities Act. It doesn't necessarily even have to be the Americans with Disabilities Act. I've been involved in cases involving the intersection of the Air Carrier Access Act, Airline Deregulation Act, state negligence laws, and the ADA, and how all of that pans out. So think of me, I'm also deaf. I was born that way. I have a genetic hearing loss, so I was born hearing, then lost all my hearing. Something just kicked in, started wearing hearing aids in fourth grade, function entirely in the hearing world with Bluetooth technology, lip reading, and advanced hearing aids. I also use voice dictation technology. My joints are all kind of weird. So I use voice dictation technology. So this is a personal and professional thing. I'm a big sports fanatic, always have been. I was commissioner of intramural sports in college. I did intramural sports refereeing and umpire and participation in law school. So I have written on the intersection of the Americans with Disabilities Act and sports for over 20 years now. And now we're seeing all kinds of issues come up about world-class athletes that have disabilities and they're beginning to come out of the closet and say, wait a minute, I'm a world-class athlete or a top-notch athlete, but I have disabilities and that means I have certain rights. So coming more and more true, Generation Z is wide open about things like that. So I'm delighted to be here.
Well, it's interesting. I think one of the things I'd like you to address, briefly, because we don't have a seminar length of time to go through it. Mm-hmm. But I think many people hear ADA, American Disabilities Act, and it's white noise, and they don't really understand its basis or its function. So could you give us a little quick 101 on the act itself?
Sure. It's divided into 5 titles. Most people think of it as employment. And indeed, 40% of my Understanding the ADA blog entries deal with employment. But there's also another title that deals with accessing non-federal governmental entities. That's 25% of my blog entries, and then there's a third title that deals with accessing places of public accommodations, which is a term of art in the ADA. You find it in 42 USC 12181, paragraph 7. And then there's a fifth part that deals with miscellaneous matters such as retaliation and interference, and one part that deals with telecommunications that never gets litigated about. So one of the things that people don't realize is that the ADA is more than just employment. And another thing they don't realize is that the ADA definition of a disability is quite broad. It's a physical or mental impairment that substantially limits a major life activity, have a record of such an impairment, or is regarded as having such an impairment. And then the final thing is each of those titles have their own statutes, regulations, guidances. So just because you know one area doesn't mean you necessarily know the other.
Now, what I'd like to focus on a little bit, obviously, we're in the world of sports, and the act clearly has some impact in the sports. I believe last week was December 3rd is International Day of Persons with Disabilities, I was reading. And in the sports world, there sort of, it gets a little muddy because, you know, on the one hand, people say, well, the act should provide everyone that wants to participate in sport should be able to participate in sport. And what are the accommodations that ought to be made? And I think part of what get lost in that, and correct me if I'm wrong, is that this disability issue is clearly should be in part of the conversation on the DE&I conversations that are more and more in vogue these days.
Oh, I agree with that. One of the things I've done since the early 1990s is I've gotten very involved with diversity, equity, and inclusion, trying to bring the perspective of an attorney with a disability to the situation. Depending on the organization I've gotten involved with, I've had more or less success. The Federal Bar Association has been fabulous. Sometimes I hit my head on the wall. At one point in time, I founded a group called the National Association of Attorneys with Disabilities. I left that for personal and professional reasons, and then it wound up dissolving. They started a new one up, the National Disabled Legal Professional Association. I'm really optimistic about that. But absolutely, and part of it is sports. Athletes don't think of themselves as disabled. And so they're really hesitant to bring it out. They're afraid they won't get playing time. They're afraid that you know, people, if you're a sports athlete, you have to be this superhuman thing. So there is a lot of that in the closet. But you know, the person from Stanford that died by suicide, where were the people? You know, if they had a process, and some universities are great about having systems in place. They had a process where that person could have turned to, oh, I don't know, peer mentors or RAs or you know, someone, and said, wait a minute, I'm really struggling with this. Can you help? But you know, part of that is athletes have to realize that there's nothing wrong with being disabled or a person with a disability, and that does give you rights, either under Title III, Title II, or Title I, or sometimes all three at the same time.
So, I mean, the example you've given raises a really interesting question. And I think most of the population, when they hear disability, they're thinking about people with physical disabilities. You might have CP, or you might, you know, have been born without limbs, or you may have been, you know, had an accident and lost a limb or something like that. But I think you're raising a really important issue that is becoming more and more discussed, and that's mental illness. So clearly from what you said, mental illnesses are part of what's protected by the ADA, correct?
Yeah, sure. And there's also a lot of hidden disabilities. Hearing loss can be hidden. The example that I started with in the whole ADA sports law universe was, you all might remember Sean Elliott. He played with one functioning kidney. And you could certainly make an argument that he had a disability. And so I invented this construct to talk about how would it play out if the coach started saying, well, I'm going to assume you can't play at the highest level because you have one functioning kidney. In that situation, they would have regarded him as having a disability, and he may have had an actual disability. And then you get into all kinds of interesting issues about what is the essential function of the job of a professional basketball player. So yes, mental issues, mental health is a big thing now, becoming more, especially with the pandemic. MH is a big deal. The ADA is really broad in what it covers. The amendment to the ADA made that really clear when the court narrowed it. So you're absolutely right. It's really hard to find a situation where a person is not going to have a disability. Whether they're protected, that's another question. but whether they have a disability, that's a hard thing to say it doesn't exist. You find very few cases that will say person X does not have a disability, so therefore they're not protected.
I remember way back when, shortly after the dinosaurs stopped roaming the earth and I was a litigator and doing real estate work, I ran into some ADA issues about accommodations in real estate. And to my mind's eye, I always thought of it, because that's what I was doing at the time, was that you had to have, that's where the railings in bathrooms came from and other things like that. But I think the concept of accommodation is far broader in the other titles you've discussed. So can you give us a little insight into what accommodation really means?
Simply put, it's anything that there's a legal mumbo jumbo I could give you, make your head swim, but simply put, it's anything that gets a person with a disability to the same starting line as a person without a disability. And then once they're at the same starting line, it's up for them to decide what to do in terms of whether they can show what they can do. So you're looking at anything that gets a person with a disability to the same starting line as someone without a disability. That's an oversimplification, but that's the best way to describe it without starting to get into technical jargon.
Well, let me throw out, maybe it's a hypothetical, but I think it addresses part of the overall specter of ADA, and that is, let's say I'm a track and field athlete, and I have no disabilities, and somebody else is a track and field athlete, and they have a disability. Let's say they're running with a blade. They have only, they have to run with blades.
Right.
What am I as an event organizer required to do to provide accommodation to that athlete? Is it simply allowing them to participate, or how deep in the weeds do you get? Is it a like competition? Are you part of the same competition? How does that analysis get undertaken?
The case in that particular area is the PGA Tour versus Martin case decided by the United States Supreme Court, where the U.S. Supreme Court said that Casey Martin had the right to a golf cart while he was competing on the tour. The question becomes, now you're getting into some legal jargon, the question becomes,
well, we're all lawyers here on this call, so.
Are you fundamentally altering the nature of the sport? Are you fundamentally altering it? So, is the person with a blade really have an advantage over the person who doesn't have one? I don't know. That would be an interesting question. The question would be, are you fundamentally altering the nature of the competition? And if you are fundamentally altering the nature of the competition, then you don't have to make that accommodation. But there's a lot you can do before that. If the question is, can you do anything before you reach that point? So, for example, a recent case got thrown out on collective bargaining grounds. But let's say a football player needs a visor to be able to play football because they have a medical condition that just makes it not a good situation for him if he's not wearing a visor. Everybody's wearing a visor nowadays. That case just got thrown out due to a collective bargaining preemption, but the accommodation there is rather straightforward. So many of these accommodations are really rather straightforward. Your example is a rather extreme situation. We had that with Oscar Pistorius, the South African track athlete who unfortunately ran into some legal difficulties at some point. But that was the big issue with him when he was wanting to compete for South Africa in the Olympics.
Now, let's keep in mind that the ADA is, the first A is for America. So in the world stage, what have you seen in the world with the, dealing with disabilities on the world stage? Are there other countries that have similar acts, or is what we have in the USA sui generis? Are we the only country that's really addressing it?
It really depends on the country. I can't say that's an area that I've gotten really involved in. I do know just from reading and talking and being involved in different groups that they can be all over the place. Sometimes they have specific laws to a particular jurisdiction. Sometimes they have countrywide laws. The philosophies are all over the place in terms of what they're trying to do with people with disabilities. There is a convention with the United Nations that is based upon, in large part, the Americans with Disabilities Act that many countries have signed on to. But you're gonna find things are all over the place, all over the world when it comes to disabilities and what the law may enable them to do.
Now, in the ADA, I'm just curious, and I have no idea, are there financial sanctions for violation of the act within the act, or is it all just up to whatever jurisdictional
No,
claim
it
might be?
depends on the title. Title I of the ADA is hooked in the Title VII of the Civil Rights Act. So that's the employment provision. You get all the remedies that you get under Title VII of the Civil Rights Act. Title II of the ADA is hooked into the Rehabilitation Act of 1973. The remedies there are under Title VI. Title II is a Civil Rights Act. The Rehabilitation Act is a spending clause legislation. That's the law that the ADA is based on. There's a real interesting question out there whether you can get emotional distress damages when you're suing a non-federal governmental entity because of a decision by the United States Supreme Court called Cummings versus Premier Rehab Keller. That Rehabilitation Act cases, you don't get emotional distress damages. But Title II is not a rehab case, even though it's hooked into the Rehab Act by its remedies. It's a different kind of law. Title III, which is the places of public accommodation, such as, let's say you have a child and you want them to participate in sports in your community, and the community gives your child a hard time because they don't want to accommodate the disability, all you can get there is injunctive relief and attorney's fees. So it really depends on the title you're after, the title you're in terms of what you can get.
So again, I'm thinking about a case that you had sent to me an article on a year or so ago that I've been wondering about for a while, which is a Pennsylvania case, track and field case that ended up settling. Do you think that had, and I don't know the particular facts of that case, but had I come to the state and said, you know, I want to be able to compete, and the state says, okay, we will have on the day of the competition, we'll have a separate 100-meter event for disabled athletes that will be after the regular athletes. Would that be considered a fair accommodation, or could that be challenged?
It'd be challenged. Separate but equal went out with Plessy versus Ferguson. And
well, obviously,
there have been challenges. I have seen challenges where the person with a disability has been successful in saying a separate but equal situation is not sufficient, particularly in Illinois. I saw Illinois try to do something like that, and they fought back and they prevailed. So it's going to be, everything turns on facts, but creating a separate but equal, I've seen that in website litigation. That's another hot area of the ADA, whether a website is accessible or not. Some places have set up a separate section of the website for people with disabilities to use, and that's been thrown out. So generally speaking, separate but equal should not be your go-to option.
Yeah, and it's interesting, and I don't know if it had to do with ADA. I would imagine it did, but the FCC required, I'm an old media guy, the FCC required that all of the networks close caption all their programming and make it available. Don't know if it was the ADA or not. It seems to be
different law.
Had to be pushed.
And that's another thing that can really confuse people is there's a lot of different laws out there that might deal with people with disabilities. So the one you're thinking about is the Telecommunications Accessibility Act. The completely different laws, completely different setup. In other areas you see Air Carrier Access Act, Fair Housing Act. Those are other laws too that get that people with disabilities wind up dealing with. So, and it can get really confusing for sure.
Yeah, and I think it's interesting though that as I said earlier, when we sort of step back into the inclusion of disabilities within, diversity, equity, and inclusion, I think there's more and more understanding and a pause before acting as to the ability to accommodate all interested parties. And it's a relatively new fact in our world, but it's people like you that are thankfully out there fighting that fight, because I think for years it was completely ignored.
Yeah, the thing that people don't realize, you're absolutely right. The thing that people don't realize is the ADA was enacted in 1990, went into effect in 1992. I did see a big difference in the attitudes of people once we were about a year into the pandemic. Then everybody started saying, well, wait a minute, disability matters, disabled matters. Maybe I need to find out just how to deal with this. And my phone started ringing much more so. I have seen in the pandemic, and now you have the whole thing about companies saying, well, let's come back to the office. And people with disabilities are saying, wait a minute, I've been doing fine for 2 years, and now you're telling me to come back to the office? And I can do the job. You've seen I can do the job for 2 years. So wait a minute. So there has been a sea change since the pandemic in awareness of disability. For sure, that was not there before.
Well, Bill, look, I can't thank you enough for taking the time to speak with us today. We just scratched the surface on what you do in your practice and the kind of work you do, which is really interesting. And where can we find your blog?
Understandingtheada.com.
Understandingtheada.com. I've read a lot of the articles. Bill sent them to me over the years. If any of you are interested in it, I would suggest just checking it out. There's a lot there. It's a robust site. And it's the end of the year here in the world, and that means it's time to renew your membership. We're in an annual membership with the Sports Lawyers Association. So please, before the end of the year, go to sportslaw.org and renew your membership. You have a little time. We won't cut you off immediately, but if you don't renew, you're going to lose the ability for all our great content and everything else on our website. And don't forget that next May 11th to 13th here in Los Angeles will be our annual conference. And the topic is the athlete. We have a lot of interesting panels over a lot of interesting subjects, and I hope to see you all there. Once again, Bill Gorin, thank you so much for being with us today. I really enjoyed our conversation. And everybody else, we'll see you in a couple of weeks. Have a great